So good morning, everyone. Thank you for being here. My name is Pinta Maguire. I am the newest member of the MedMal team, and I'm thrilled to join the Gluckstein MedMal team. And this morning, I'm going to be talking to you about damages for 45 minutes, so I apologize already. I hope you have a coffee. They scheduled this topic first thing in the morning. And I want to, so a little bit about me. I started out on the defense side. I worked actually very closely with Risa Kirschblum for a number of years. She was one of my very first mentors. And she's probably one of the reasons why I went into medical negligence, although saw the light after about so I started out on the defense side before I saw the light and switched to the plaintiff side, about 13 years ago. And I'm going to let you in on a little secret from the defense side, is that most defense lawyers hate damages. And when I was on the defense side, I was certainly one of those lawyers. Liability was the fun part, learning the medicine, cross-examining experts, picking apart causation theories and credibility. That was exciting. Damages, not so much. Felt like spreadsheets, math, endless arguments about hourly rates and inflation indexes. But once I moved to the plaintiff side, I realized something, that while liability brings the drama, the damages are really how our clients realize and build a better future. It's the measurement of the human cost of what they've lost. And for our clients, it's really the only pathway they have to restoring dignity, stability, and independence after life-altering events. Now, most of the time, we never see damages argued at trial. They're settled in advance of trial, and that's typically a good thing. But getting there takes an extraordinary amount of coordination. In our complex birth injury cases, brain injury cases, stroke cases, we often have 6, 10, 12 damages experts that we're dealing with, and that's even before we're dealing with treating experts to support our claims. The reports are long, and there's a lot of math. I highly recommend learning to embrace Excel. But those numbers, they're not just numbers on a spreadsheet. They're the roadmap for our clients to rebuild their lives. So when I told my new colleague and mentor, Richard, about the title of this presentation, Maximizing Damages in Medical Negligence Cases, he looked at me and gave me that look, that if you know Richard, you know that look. And he said, Pinta, I don't like that. We don't maximize damages. We quantify loss. We push for fair recovery. And of course, I went away and thought about it and quickly came to the realization that, newsflash, Richard was right. I've learned that. I've only been working with him for 3 months, but I have learned that Richard is right many or most of the times. Because our job is not to maximize damages. That implies we're inflating our claims. Our job is to measure them with honesty, precision, and empathy. And I suggest, and I don't know if there's any defense counsel in this room, I suggest if there are, this same applies to you. Your job is not to minimize damages. Your job is to hold the plaintiffs to account to ensure that the damages claimed are legitimate and justifiable. And that's how you build credibility with the court, with opposing counsel, and with our clients. And so officially, the new title is Quantifying Justice, Achieving Fair Recovery in Medical Negligence Cases. Are we happy? Yes. It's not nearly as dramatic, but it's exactly what we're here to talk about. And we're going to start by talking about where the concept of fair recovery came from, the Andrews Trilogy, and that laid the foundation for damages law in Canada. Then we're going to go over some of the core principles that arise from that trilogy and how they relate to debates that I see all the time in future care plans regarding institutional or private care versus home-based care for disabled children and adults. Then I would like to talk about causation and how that relates to damages, because I find that defense counsel often conflate those two issues. I'm going to touch very briefly on all the different categories of damages that we as lawyers need to think about when we're pleading these cases and the evidence that we need to prove them. And given the civil rules reforms that are coming through, we need to start thinking about that evidence much sooner in our cases. And then I'm going to wrap up the presentation with two areas where I think there remains a lot of confusion. I see experts on both sides deducting benefits that they shouldn't, and lawyers getting life expectancy opinions when they should not. So let's start at the beginning. The Andrews trilogy. Because everything in the damages space is built on these three cases, and they were three cases that came down from the Supreme Court of Canada in 1978. That may or may not have been around the time that I was born. But it's the Andrews and Grandin Toy, Arnold and Tenno, and the Thornton and School District case. And they're known as the Andrews trilogy, and if you haven't read them recently, I suggest going back. I go back every time I have a complicated damages case, and I swear I find a nugget in those cases every single time I do. They are the backbone of our modern damages law in Canada. So I don't know about you, if you are dealing with potential new clients as lawyers, I repeat this phrase many, many times. We are not like the US. Our damages awards are not in the many millions of dollars. In 1978, our Supreme Court of Canada put a cap for $100,000, blah, 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 adjusted for inflation, $470,000, but that's reserved for the most severely injured people. Quadriplegia is often the example I give, and that example, of course, comes from the Andrews cases. And these all involved damages assessments of severely injured individuals, and it's famous for implementing the cap on general damages. But leaving the cap aside, there's actually a lot of profoundly plaintiff-friendly principles that come from this trilogy. So briefly, the facts of Andrews. Mr. Andrews was 21 years old. He suffered catastrophic quadriplegia after being struck by a car driven negligently by a Grandin Toy employee. He required 24-hour care, medical assistance, and the plaintiff, of course, sought full compensation for lifetime care costs and loss of earnings. And they argued that institutional care was inappropriate, that he should live at home with full attendant care support. They argued that damages should reflect dignity, independence, and human value, not mere subsistence. The defendant's position, of course, was that, they accepted liability, which is not something I typically see in med-mal cases, but they argued for significantly lower damages, and they argued that institutional care was adequate. It's good enough for everyone on the public system, so it should be good enough in the tort system as well. They argued that large awards would burden insurers and society. So in Andrews, the court rejected the minimum standards approach. They held that damages must restore comfort, dignity, and security. And those are some words that you're going to hear a lot in this presentation, and I suggest that those are the words that we should be using when we're thinking about damages. We're thinking about restoring comfort, dignity, and security for our clients. Andrews found that the home-based care is preferable because it promotes quality of life and it sustains life. Now, I put some of the nuggets that I love from the Andrews case, but I'll just go through some of them. So one of the things I hear from defense counsel a lot of the times is that, well, this therapy isn't going to improve the health of the injured person. But Andrews tells us that to the extent that money can be used to sustain or improve, so it's enough that function is sustained, then that can be part of the damages claim. There's a duty to be reasonable, but you can't expect family members to provide care on a gratuitous basis. And Andrews stands for the principle that families are entitled to be compensated for the care that they provided to their loved ones. And I love this phrase as well, whether the reasonably minded person with ample means would be ready to incur the expense. That is the test of reasonableness. So yes, it establishes a cap on general damages. That's what it's known for, but it also has a number of really wonderful principles that we can use to weave into both our mediation arguments, pretrial arguments, and of course, throughout our reports. The second case, of course, is Arnold and Tenno, another tragic case involving a 4-year-old who suffered a catastrophic brain injury after being hit by a car. And the parents really pushed to have their child cared for in their home environment, and they really emphasized the moral obligation to ensure that catastrophically injured children should be able to live at home in comfort and dignity. And again, the defendants argued that the damages should be strictly limited to a basic institutional care model. They argued that there is a public responsibility to provide care for these injured individuals, and that the court should incorporate that into the damages assessment. And again, the court rejected that. Cost savings do not justify institutionalization. The law's role is to ensure that the life care plan is decent and comfortable, not lavish, but not meager. But importantly, they endorsed a family model of care, recognizing its important economic and social value. And finally, the last case is the Thornton School District case. This involved a young man, 18, who was rendered quadriplegic after diving into a high school pool. The school was found negligent for inadequate supervision and safety warnings. And this case really lays the groundwork for a future loss of income claim, because the defendants argued that any loss of income claim of a child is inherently speculative. But the court found that the future earning capacities must reflect the realistic opportunities that the injury destroyed, even if they weren't fully realized. And again, they confirm that family-based community care is the preferential model. So every time we build a damages claim, we're applying these principles over and over again, not enrichment, restoration. That's what we are pushing for our clients. And the language matters. So these are some of the principles that come out of the Andrews trilogy, some of the advocacy focus that we can focus on as advocates, and the practical technique in turning these principles into dollars. So language matters. We have to use language that I say is reflective in these Supreme Court of Canada decisions, much like we do in the liability, or with our liability experts. We need to justify the expenses. Every single line item needs to have an evidentiary foundation. The damages must be reasonable and evidence-based. And again, you can frame it this way: would a reasonable person with ample means incur this expense to preserve or improve their function, security, dignity, or comfort? The answer to that question is yes, you have established reasonableness. And the third principle is that the courts have resoundingly rejected institutional care. That's both private and public. Unless there is compelling evidence that that model of care would be in the best interests of your client. And this isn't just good advocacy. Sorry, I'm just trying to get this to work. It's consistent with the law and the modern policy direction from our own health and social services systems. About 10 years ago, the Ombudsman of Ontario released a report called Nowhere to Turn. And they investigated 1,400 complaints about adults with developmental disabilities in crisis. The investigation ran from 2012 to 2016, and what they found was truly horrific and heartbreaking. Literally injured people or disabled people. One gentleman, young man in a long-term care home whose wheelchair was damaged, had to wait 6 months for a new one, and during that time crawled around on the floor for 6 months. When they finally got the wheelchair, he was quite upset with his state of his life, acted out, injured one of his elderly co-patients, and was then sent to a psychiatric facility because they felt his behavioral problems were too problematic. And that's what the Ombudsman reports found. They found thousands of adults still waiting for housing and supports, the demand vastly outstripping supply, and families waiting years for placements. And despite a policy shift towards community-based care, many people with complex needs were ending up in hospitals, long-term care homes, or even jails because there were simply no suitable community placements. And there's a human cost, of course, and we see that with our clients before they get access to compensation. They are exhausted, they are burnt out, and they are terrified of what's going to happen if they are not able to provide care for their loved ones any longer. So these are the real life consequences that we have to think about when defense counsel are putting forward institutional care models. And the idea that care should happen in the home, in the community, isn't just a moral principle or a legal principle that comes from Andrews. It's now legislated in Ontario. So in 2019, the government passed the Connecting Care Act, which replaced the old Home Care and Community Services Act. It created a new framework, one that explicitly recognizes a patient bill of rights under Regulation 187.22. That regulation says that home and community care must promote autonomy, participation in decision-making, and be sensitive to the person's needs and preferences. So when we, as plaintiffs' counsel, are pushing for home-based care with individualized supports, we're not being idealistic, we're aligning with the province's own legislative mandate. Our system, as meager as it is, now funds not-for-profit agencies and in some cases directly funds families caring for disabled individuals, and that care is almost always presumptively in the home. That's the model of care Ontario says it wants: community-based, family-driven, and dignity-centered care. That's the goal of the province, and it must be our goal as plaintiffs' lawyers when we put forward these plans. Any suggestion otherwise, frankly, is unsupportable. So even though the Andrews Trilogy told us decades ago that care should be home-based and dignity-centered, this issue remains a contentious one, where extensive home-based supports are required to support a severely disabled individual. So have things changed since this report came out? Not really. So last year, Community Living Ontario, which is an advocacy group for individuals with intellectual and developmental disabilities, they released a press release, and it was literally, I think, called a call for help. And so they looked at what had happened since the Ombudsman report in 2016, and unsurprisingly, things have gotten worse. As of last year, there were over 52,000 people on waiting lists for support services. That list gets longer every year. The system is housing 5% fewer people now, or in 2024, than it did in 2018. And the wait list has grown by over 55%. And the wait list for full allocation, so this new community-based care program, a lot of these services are administered through something called the Passport program, sorry about that, where you can apply for maximum allocation. That maximum amount that families can get is about $44,000 a year. It's not enough, we know, for these care plans. But that wait list, the wait list to get access to full allocation has doubled in the past 5 years. And so while government and funding to these agencies has only increased by 7% since 1993, the cost of living has gone up by 60%, and that gap is being borne by families. And that's exactly why the Andrews principles matter so much when we go through damages, when we think about damages. Because we're standing up in court to say that home care is the presumptive model, and we're not just talking about theory or what our experts are saying, we're talking about a system that is breaking under the weight of underfunding. And we can't be adding to that by putting individuals who have someone that they can demand compensation for. Because that burden shouldn't fall on families, it shouldn't fall on the patients, it should fall on the tortfeasor who caused the harm. So let's talk about causation and damages and how those fit together, because I find defense counsel love to blur the line. I've heard this many times. I've heard that if there are other contributing factors to your client's injury or deterioration, we haven't proven causation. I'm always a little reticent to mention causation cases in front of that man, but Athy and Leonati is probably one of my favorite, because it says that the plaintiff doesn't have to prove that the defendant's negligence was the only cause of the injury, just that it was a cause. And once that is established on a balance of probabilities, the defendant is fully liable for the injury. And that's the part that I find the defense counsel mistake. Yes, they can argue for a deduction for pre-existing conditions and how that would have affected the plaintiff. That's the classic thin skull versus crumbling skull argument, but that is not a reduction on liability. That is a potential negative contingency on the damages calculation. And ATHI also sets the standard of proof for a damages case. It's not the same standard as in proving causation, it's lower. You only have to show that there is a real and substantial possibility that the expense will be incurred in the future. And that is proven through expert support, through life care planners, OTs, vocational experts. All of those experts are key, and they help transform what might seem speculative into measurable and defensible plans. So yes, defense counsel can raise pre-existing conditions, non-tortious conduct as contributing, but that is actually their evidentiary burden, and it only affects the damages calculation. It does not affect causation. So we need to hold defense counsel to account when they argue that these pre-existing conditions somehow affects our ability to establish causation. That's not the case. It may factor into the damages assessment, but that is their evidentiary burden to prove. I've also added this quote from Krangle, which is a recent 2002 Supreme Court of Canada decision. But Justice McLaughlin said, which is a great quote, that future care damages are a matter of prediction based on the evidence of what is likely in the best interest of the injured person. So again, these principles weaving what is in the best interests of the injured person, what is going to restore their dignity, what they need for their security. These are the principles that we should be weaving through our damages analysis. So this is a list of, or probably a non-exhaustive list of all the things that we should be thinking about when we're pleading these cases. And it's not a way to maximize damages, it's a way to build our damages in a principled way. The last two, the present value and no deductibility, I'm going to talk about those a little bit more, but we need to think about whether we're going to be pleading loss of income, whether we're going to be pleading loss of residual earning capacity, loss of competitive advantage. When I was doing some research for this presentation, I found it really interesting that in Ontario, the loss of interdependent relationship claim is usually used to increase or non-pecuniary and future income awards, but in the West, it's actually calculated as a loss of support award. So if you can establish that the injury impacted the injured person's ability to engage in a relationship that provides some financial security, you can actually sue for the loss of support, much in the same way that you could in a fatality claim. I found that interesting, and I think it's something that we should try and bring into this province. And what do we need to build damages? We need a whole host of experts to support us. And that's where communication with our future care planners makes a lot of sense, and that communication should happen early on and often. So in the birth injury cases are a little bit different. We have a lot of expertise in those. We know kind of the damages that we're going to be claiming, but sometimes I'm dealing with a strange anoxic brain injury case, and I'll call up my life care planner and talk to them about the injury and say, who do you need to hear from to support the recommendations that are going to come out? And so we get started on getting those assessments lined up, because as I said, it takes an intense amount of coordination to get all of these experts and assessments on board and then weave them into our future care plans. Okay. So deductibility of benefits. One of my biggest pet peeves when I see this in defense future care plans is when they suggest that there should be a deduction for any amount of money our clients are receiving through government benefits. So that it would include the passport program that I mentioned earlier. It can include the Ontario pharmacy benefit for children under the age of 21. It can even include the assisted devices funds. It can include ODB. And this is the golden rule. Should be no deduction for publicly funded programs, because publicly funded programs, the future is uncertain and discretionary. And if you cannot establish that the payment is mandatory, so ODB, the payment is mandatory, but the courts have said even in the case of ODB, the courts must assess the certainty of benefits continuation. And there have been cases where the courts have awarded a percentage of the ODB funds that were allocated or were determined that would be covered by ODB on the basis that there's a percentage chance that that is not going to continue in the future. So simply because you are eligible for a benefit doesn't mean that you're going to get it. And there's no guarantee that it's going to continue. And so our courts have said in the McLean and Wallace case and the Butler and the RVH case that if anyone should bear the risk of reduced or continued funding or discontinued funding, it should be the defendants and not the innocent party. Now again, thinking about the upcoming rules changes, we might have to call evidence from the directors of these programs to talk about wait lists and eligibility and funding shifts, but that public funding discount that we typically see in these future care plans from Defense Counsel, they're not based on sound legal principles, and in fact our courts have said the opposite. And the same is true for the deduction of private benefits, like long-term disability. Long-term disability is not deductible. Cunningham and Wheeler, another Supreme Court of Canada case, is still good law, and they're not entitled to deduct any subrogated claim. The obligation to repay is between the plaintiff and the third party, and the defendant does not get the benefit of the deduction. So I'd like to wrap up this damages discussion by talking about one of the most important and often misunderstood tools for achieving fair recovery. That is the structured settlement. Our bronze sponsor, McKellar's, probably loves this slide. But in Ontario, under Section 116.1 of the Courts of Justice Act, plaintiffs are entitled to structure their awards if they exceed $250,000. And if it exceeds $250,000, the court shall, in its mandatory language, on motion, order payment by structured settlement, so no lump sum. And that means the payments are made through periodic tax-free annuities tied to the plaintiff's actual lifetime, not some actuarial projection. The payments are fixed to cover the real ongoing costs of care. So this is especially important when you see defense counsel trying to file life expectancy reports and present value calculations for future care, trying to chop down the future damages, the future care claims, because under 116.1, as long as the future care is going to exceed $250,000, that is legally irrelevant. What the life expectancy Dr. Armstrong or whoever the life expectancy expert is going to say, it's irrelevant to the assessment of what the structure cost is. The whole point of the structure is take risk out of the equation. The plaintiffs are guaranteed payments for life, and that risk is borne by the insurer, not the plaintiff. And the idea for structures was actually born out of the Andrews trilogy. The justice in those cases contemplated that periodic payments for life over a lump sum were preferable, but said that they couldn't do it. They had to wait for the legislature to enact that. So fast forward to the early 1990s, and after years of discussion with the Ministry of Attorney General, plaintiffs' lawyers, insurers, the CMPA, finally the government acted. Section 116.1 was enacted to give exactly what the Andrews judges wanted, a way to provide structure, secure, tax-free compensation for life. And back when it was enacted, it was preferable over the lump sum payment. Now, with the cost of structures, if your client is severely injured, those costs can be, those structure quotes can be quite extensive. But when you get grumbling from defense counsel and they say that the cost of structures are too expensive and we should be looking at life expectancy, I like to point out that the CMPA wanted this. This is what they pushed for from the 90s. And when the bill that approved Section 116.1 was before the legislature, Dr. John Gray, who was then the CEO of the CMPA, he testified, and I'm quoting from his remarks, in many cases, a lump sum award is a blunt instrument. It is difficult to predict life expectancy, and it is unfair to both the plaintiff and the physician to gamble on that prediction. Structured settlements provide fairness. They ensure that the injured patient will have care for as long as they live. So when the CMPA tells you that structures are too expensive, you need to shut that down. You need to tell them that I'll take your life expectancy report and I'm going to throw it in the garbage over there because it has no bearing on what my client is entitled to. The dignity and security of our clients require lifetime structures, and we should not be accepting any suggestion from defense counsel that life expectancy plays any role for our severely injured clients. So here are some key takeaways from this presentation. I hope you enjoyed it and it wasn't too painful first thing in the morning. We need to ground everything in purpose. Damages are about restoration, not enrichment. We need to build credibility for our plans through evidence. We need to quantify and prove every loss. We need to combine expert witnesses with lay witnesses, with treating physicians. We need to humanize the need of our clients. Do not plan for institutional care. Do not include it in your plans. And there is good reason for that. The government is not supportive of that, and that is not what our clients are entitled to. Do not discount for government funding in our damages plans, and we need to always structure for the security of our clients. As we talk about damages in our submissions to the court, in our writing in the court, we need to use language that reflects the restorative language that comes out of Andrews, like rebuild, preserving, maintaining independence, anchor the narratives in humanity. And we need to advocate for the full measure of recovery, not perfection, but what is fair. That is it. Any questions?